Thank you both for joining me here today. How are you? Like I said, I have Leanne on the phone here who is joining us, and I have Shefali here virtual. How are you both?
Thanks, Khadija, for that introduction. I'm doing very well. How are you?
I'm doing well. It's busy. I'm trying to put things together, but keeping myself preoccupied and just surviving. That's really it. That's all we could do. Take it day by day. Yeah. Leanne, how are you?
I'm good, thank you. Good afternoon to everyone. Glad to join you all.
Wonderful. Everyone can I just get a quick thumbs up that everyone can hear Leanne? We're good on this end? Yep. Perfect. Okay, good. All right, so it's so great to have you both here with me today. We look forward to hear you share your knowledge, tips, and solutions on employment rights, as well as today's topics of discussion. And like I said, we also have Rosa joining us here from Can Talk. She will be our interpreter for our French-speaking attendees. Speaking of attendees, to those who are in attendance, I'd like to thank you all for joining and also invite you to be a part of today's conference by sharing your questions using the Q&A option or the chat option at the bottom of your screen. I believe there is a Q&A and a chat option at the bottom. So feel free to ask questions pertaining to today's discussions, and we will be more than happy to answer them throughout this conference. Right off the bat, I'd first like to start with both, with a question for you both, for both Shefali and Leanne. I would like to know a little bit about your backstory. What led you to pursue a career in employment law? Shefali, may I start with you?
Sure, absolutely. So, well, as you all heard from my introduction, my roots are from India, and I practiced law in India for a while before I moved to Canada. Interestingly, I did not just practice employment law back in India. I did a mixture of corporate law, employment, and real estate law, because that is what the need of the hour is. That is what my firm demanded. And it was quite common for lawyers back in India at big firms to pick up multiple fields of law and just run with it rather than have one particular field of expertise, unless of course it was tax. Obviously, that changed very quickly when I moved to Canada. And I learned that, employment law in and of itself is huge, and corporate and real estate too. They're all different fields, and typically you just stick to one. So I knew in that moment that I'm going to stick with employment law and leave behind my corporate and my real estate experience. Also because back in India, employment law was not as big an aspect to just practice only employment law. There are lots of employment rights back in India, don't get me wrong. It's just that the awareness of that is much less as compared to what it is here in Canada. Mm-hmm. So obviously I gravitated towards employment law here when I moved, and there's been no turning back. And I love helping my clients navigate the employment law field here in Canada.
Wonderful. Thank you for sharing a little more about your backstory, aside from what I mentioned earlier. Leanne, we would love to hear your backstory and what led you to pursue a career in employment law.
Yeah, my story started before paralegals were regulated in Ontario. And I was going to school to study business and law. I wanted to get into finance and areas like that. When I graduated, they were talking about regulating paralegals, and I was offered a job through one of my classmates in an employment law firm, and it was an area of law that I took to very quickly. I understood it, but I also saw that it was an area of law that was completely unrepresented by paralegals, despite the vast need for paralegals in this area. So, when I took my first job at that firm, the firm ultimately shut down within a year, and I decided that would be a good opportunity for me to launch my own practice and to focus solely on employment law. and the need for it has actually grown over the years. And I've been able to expand my practice, and been doing it since 2006 exclusively.
Mhm. Nice. Well, thank you for sharing that. And you mentioned employment law, and saying that there wasn't much of I guess, a need or a rise for paralegals. And I'm not sure if it was mentioned, but why is that compared to a lawyer? What would be the difference?
Well, traditionally, paralegals have always dealt with things like provincial offenses and landlord-tenant, small claims court. There hasn't been a lot of exposures for paralegals doing employment matters in the small claims court. In 2005, the small claims court limit, I believe, was 6,000, and it went up to 10,000 shortly thereafter. So lawyers weren't interested in these cases, and there just wasn't an area for paralegals to be trained. So generally, paralegals, when they would come out of school, or even before then, when they weren't, right around that time, they would just go into these tried and true areas where there was an abundance of work for them, such as like traffic tickets and landlord-tenant matters. Not too much in a small claims court, although some of them did do generalized practices. I had the unique opportunity of working for a law firm, or lawyers that did employment law, but they started their own paralegal firm within the firm. And so we were independent of them, but we had their support when it was needed. And I worked for them for a year. And at the end, I completely immersed in it, but I loved the work so much, I picked it up very quickly. And when their law firm inevitably, the owner of the firm died, unfortunately, so the firm didn't survive, I could either go work as an assistant or do traffic tickets. But I decided to start my own law firm. I felt strongly enough about employment law. At the time, there were, I think, one or two other paralegals that did employment law. They were more experienced than me at that time. I don't know if they're still practicing or if they've taken on other areas, but there were very few paralegals. And even now, there are very few paralegals that do employment law. Yet it's such it's a massive area of law that's really unrepresented, because lawyers, the claims are too small for lawyers to take on, and the further outside the GTA you get, the less paralegals there are available to the public. So I think it's an unrepresented area specifically for paralegals, considering how many lawyers there are in the industry. You would think there would be more paralegals doing this work. So it's an industry that's about to grow and boom, as I see it.
Nice. Well, thank you for sharing that. I'm glad to see that there is a more exposure for paralegals. I think it's very important. What I'd like to discuss now, moving on further deep into employment law, is what differentiates what is the difference between human rights and employment rights, and how do human rights protect us in the work environment? Shefali, may I start with you?
Sure, absolutely. So employment rights typically are the rights of an individual in a workplace, mostly to do with terms and conditions of employment. These rights really vary depending on the type of workplace. For the purposes of today's discussion, I understand we are focusing on provincially regulated workplaces, but otherwise there's a difference between federal versus provincially regulated workplaces. And in saying that, when I say that, there are different terms that apply to employees who work in a federal institution versus a provincially regulated company. It also depends on the work status. For example, if the individual is a manager versus a non-managerial position. But human rights are the basic rights and freedoms that apply to every person in everyday aspect. They are based on important principles like dignity, fairness, respect, equality, and they don't just apply to employment, but they apply to service providers and independent contractors and volunteers. And many of the principles of human rights are designated to protect individuals as a worker too, within the workplace. For example, employees have rights not to be discriminated against based on certain grounds that are enumerated in the code. There are specific grounds like race, citizenship, sex, family status, disability, and etc. And again, you have to be mindful that these are provincially regulated legislation. So we're only focusing on Ontario Human Rights Code. But when you contrast it with Human Rights Code in BC and Alberta and in other provinces, the underlying fundamental principles may more or less remain the same, but these grounds at some point differ. So it's very important to understand that. So it's kind of a subset, human rights and employment rights specifically to do with employees and the terms and conditions of employment, but human rights do apply to employees as well, but they also expand into other areas.
I see. Thank you. And who, Leanne, if you don't mind answering this, who is qualified for these rights, for the protection of the rights in Canada? And do these rights apply to, for example, newcomers coming into Canada or those who don't have a Canadian citizenship? Who qualifies for these rights?
Well, in Ontario, if you work in Ontario, you are protected by the Employment Standards Act and the Ontario Human Rights Code. Or, if it's a federally regulated company, the same would apply. So basically, everybody, if you work in Canada, you are protected, whether you're a migrant worker or a newcomer. These rights and protections apply to everyone equally.
Nice. Okay. One thing I know upon official employment for employees is that they are automatically given the right to work, the right to know about their work conditions and what tasks lay ahead of them, and then also the right to refuse. So the Occupational Health and Safety Act gives employees the right to refuse unsafe work. Does this apply to COVID-19? Does this apply to the COVID-19 pandemic? Can an employee refuse to work due to the pandemic? This for Leanne.
So that question is for me?
Yes. So I was just saying that the Ontario, the Occupational Health and Safety Act gives the employees the right to refuse safe work. And so I was curious to know if this also applies to the COVID-19 pandemic and if an employee can refuse work due to the pandemic.
Well, an employee can refuse work if it's unsafe, absolutely. And that would apply to the pandemic equally. Now, with the pandemic, there are a lot of new issues being raised that have never been raised or addressed before. So there's nothing in law that speaks to it specifically yet, which these things are coming about. So each case would have to be taken on a case-by-case basis. If the employer was not providing the proper protection and equipment, for example, the plexiglass shields or masks, or they were not observing COVID protocols, then yes, an employee could refuse work. For example, a restaurant owner refused to do COVID passports. And then absolutely in a situation like that. Now, if it's subjective, if the employee is just nervous about the general COVID issue, that's a different matter entirely. It really falls on what the employer is doing to put the proper protections in place for its employees, and are they reasonable protections?
Nice. Now, what about, Shefali, if you wanted to add on to that as well?
No, that's fine.
Okay, perfect. Now, Leanne, what about, let's say a employee says to their employer that their doctor has instructed them to stay home for a couple of weeks, but the employer says, no, you must come into work because we are understaffed. Is an employee allowed to Like what should they do? And are their rights violated? Have their rights been violated in this situation?
An employee is not required to return to work if the employer if the doctor is saying they need to stay off work. Absolutely. Even if the employer is short of staff, an employer is required to provide accommodation up to the point of undue hardship. So, in a situation like that, the employee can refuse to return to work. Is it wrong for the employer to ask? Not necessarily for the employer to ask. If the employer harasses or threatens or punishes the employee for not returning to work, absolutely that is wrong. And keep in mind, you can't stop the employer from doing something wrong. So if the employer says, you have to return to work despite what your doctor says, or I'm going to consider you as abandoning your job and terminating you. You can't stop the employer from doing that, but it will trigger human rights damages. That is a violation of the employee's rights. They, as I said, the employer must require accommodation up to the point of undue hardship.
Nice. Thank you. Thank you for answering that. That was a question that was given to me by someone. So I hope that answers their question in this situation. That's very unfortunate to ever be in a situation where your employer is demanding that you return to work despite your doctor's orders. Shefali, my question to you is, another scenario-based question is, a person's contract states that they can only work a maximum of 40 hours per week. Last week, their boss made them work overtime for a total of 46 hours. Is this illegal? And what would be the protocols or the steps to take if should they feel like their rights have been violated?
Well, first of all, I don't think it's illegal per se. Yes, the contract says that the maximum hours would be 40 hours. Assuming that this is an employer that's provincially regulated, overtime in Ontario per statute only starts after 44 hours, and you can get employees to work extra time regardless of what your contract says. But if it says 40 hours, that there's a very good argument to make that the additional 6 hours that the employee worked would be paid at a different rate, which would be compensated at an overtime rate, which would be higher than the regular rate. And again, the employer has a couple of options when it comes to overtime and overtime rate. The default is that if an employee ends up working more than the set number of hours, if the contract provides for a lesser number of hours than what the statute provides, which is the case here because the statute typically is 44 hours in a week, then in that case, they're required to be compensated at an overtime rate of 1.5 times their regular rate. But if an employee agrees to it in writing, then the employer has the option of, instead of paying them overtime pay, they can provide the employees with overtime time off in lieu, which would be basically 1.5 times of extra time that they have that they can use to take off. So, so the answer to the question, is it illegal? No, but you'll have to go back and check whether or not you were compensated sufficiently for the extra number of hours that you worked.
Absolutely, absolutely. And by doing so, not results, but to do that would mean to check your pay stub, I assume, correct?
Correct. It's either that or check with your HR professional, whatever is easy to do.
Perfect. Thank you so much for answering that. Leanne, we have a question, an anonymous question for you here in the Q&A chat. Hoping that you could answer this one here. It says, what is the appropriate legal claim in a situation where a person arrives to Ontario on a closed work permit, and on arrival, the employer advises that they don't have a job for them anymore? Would you like me to repeat that?
No, I've heard the question. A lot of it would depend on the employment contract itself. And what if the contract has some sort of exit clause, but there have been situations where that happens. Say regardless of the work visa. Again, if you're if you have a contract in Ontario, then the laws of Ontario would apply. So if you had an employment agreement with somebody working in Ontario, and then they breach that agreement, that could trigger damages for that agreement. Hard to gauge what those damages could be. Given the nature that I work in the small claims court, they tend to, in Ontario, those damages could run as much as 4 months, depending on the situation. That is a difficult scenario because of the immigration. Immigration does make it harder because you do have to pursue it. So if you're not in Canada, then you have to consider how do you pursue it if you're not here.
Right.
However, if you are in Canada, I raise that issue because we're talking about a work permit, because if you can't work, then how do you stay? Mm-hmm. But if you are in Ontario, then the laws of Ontario would apply to the work contract, regardless of the employment or the citizen status or the working permit, as long as they were working legally.
Okay, thank you for answering that question. I hope that does answer your question to whomever asked that question. I hope that provides some insight and some knowledge towards you. Folks, again, just a quick reminder, feel free to type your questions in the chat box below or in the Q&A question. We'll be more than happy to answer this question to the best of our abilities. I say our, but I mean Shefali and Leanne. I'm just the host here. Oh my goodness. Okay. Let's discuss a little bit about employment red flags. We've heard that word before. When we think of red flags, we think, oh, things we need to be cautious about, things we need to look out for. So under the topic of employment, what are some red flags? This is for both of you, for whoever wants to answer first. What are some common red flags that attendees tend to overlook in the work environment? And my follow-up question would be, how can an individual become more aware of these red flags? This could include, before when they're applying for a job, when they are officially hired in said position, in the environment, in the workplace. So what are some common red flags that employees tend to overlook that they should be more aware of?
I can jump in on the first part at least. So some of the things that employees should be thinking about when they're interviewing or it's as part of the job process is ask a lot of questions about the role itself. Try to understand what your role entails. A lot of times we see issues where the employee or the prospective employee misunderstood the role, and then there's a disconnect between what was expected versus what was promised versus what is being provided. So that's one thing to watch out for. Yes, job descriptions as part of the interview process is a big thing, but also ask a lot of questions as part of the interview on the job description to understand and clarify any questions that you have, rather than assuming that this is what it is. And then I guess that's part of the main question that you would try to understand as part of the interview process. But I guess there are lots of other red flags that you would probably pick up on after you start working. A couple of things that come to mind are lack of transparency. You're working and you get no feedback whatsoever from your work providers or your managers. Not a good sign. Try to, even though you're not getting feedback from the employer, I think it's always a good thing to voluntarily ask for feedback and try to see how you're performing, whether you're meeting the performance metrics and all of that, so that there's no issue towards the end of the year where there's some issues that crop up. Another important issue is no recognition of work. You're working and working and working, and there is absolutely no sound from the employer. There's no recognition whatsoever of the work that you've put in, of the effort that you've put in, and the work product that's come out. No direction on role. That's very, very important, especially in a virtual concept now. That's what we've been doing as part of the pandemic. Tons of people are starting new jobs virtually, and they get a job description as part of their hiring process, get no clear direction on your role, you're on your own. That's not a good sign. You need to speak up, ask more questions, try to get more direction on your role. The other thing that you need to keep in mind is lack of teamwork. That's very key. Trying to work independently in a virtual setup is good if that's what your role requires. But if not, 90% of many roles that you take up in whether be it in a tech field or any other field requires some sort of teamwork to be done. If you're not getting that support, that's a problem. And I guess lastly, also to keep in mind is attrition rate. Attrition during the pandemic has been a completely different topic, but back in the old days where when there was a lot of attrition, it's always important to keep that in mind as is there a real problem with the workplace with the attrition, or is it just because people are finding other opportunities that they're trying to move on for?
Mm-hmm.
So I think those are pretty much some of the things that employees need to keep in mind while they're interviewing or after they start working at a new place.
You mentioned a couple points there, key points that we will be discussing further on in the conference. So I will definitely go back to what you said in a moment. But Leanne, I would like to hear from you. What are some red flags that employees tend to overlook in the work environment? And this includes prior to being hired as well as officially being hired.
Well, I think that, I'd more like to expand on the answer that was already given, because that was a very, very well-rounded answer. And my experience has been more with people, what they experience, in the workplace and during the termination. And they often go hand in hand. But a couple of red flags that I'd like to add to are, respectful treatment. Are you treated with respect in the workplace? You don't think that it might sound trivial, but that can, if you're not respected, duly respected, not, worship, but properly respected, that can lead down a path of worse treatment. And it can allow people or give people an opportunity to treat you badly, such as treat you differently, deny opportunities that are given to other employees in your position, not recognize the work that you do, punish you for behavior that other people are allowed to do, such as everybody shows up for work 5 minutes late and you show up 1 minute late and you're getting written warnings, and fairness in the workplace. Are you treated fairly? Are you treated like your coworkers are? Those are some big red flags. But you asked, it was a two-part question, and if I could, transition into the second part question, how do you deal with it? Mm-hmm. Well, sometimes the red flag is nothing. It turns out to be nothing. It's somebody having a bad day, or maybe you're having a bad day and you're too sensitive. So don't jump on everything that comes up right away. Begin to observe behaviors, take note of them and address them. And if they're not, if your concerns are not being addressed, then you need to start thinking about, well, what's next? If I can't deal with this in the workplace, how long can this be sustainable for? And how do I protect myself if things go badly? You need to start documenting things, collecting the evidence that you have to show that you've tried to inform your employer, that you've tried to improve the situation. You need to let your employer know how you feel and put it in writing. Make sure that you have a copy of that so that you can say, I did try to address these matters with my employer, because ultimately, if you're terminated, these could lead to damages, or it could lead to a more substantial claim, especially if there's human rights involved. Mm-hmm. If you're being treated differently on grounds that are protected under the Human Rights Code.
Right. Well, thank you both for those those tips and solutions. I think that was very helpful. A couple things that was mentioned that I want to touch base on. Shefali, you mentioned misrepresentation under the lines of you go for your interview and they say one thing, but it's something else. So I just wanted to talk just a little bit more about that along the lines of wrongful hiring. For those who aren't aware of what that is, it's another way of saying fraudulent misrepresentation. So you go for an interview, a company promises you one thing, almost as if they were over promising, but then they weren't delivering it once you were hired. So I just wanted to talk a little bit more about that with you, Shefali, and just to discuss what it is, and then how and why do candidates fall victim to it? What draws them in to the point that it would be considered wrongful hiring?
Yeah, I think the fundamental issue there would be, like I said, where employees or prospective hires fail to ask those relevant questions about their job description. Sure, a job description may look perfect and flowery and too good to believe. Oftentimes it's probably true because you're joining a great company, but sometimes it's unfortunate that they just overdid it and they try to overpromise, and at the end of the day it's just like an over glorified it says it's a managerial position, but it's probably just over glorified clerk, and you are utterly unhappy. So in a situation like that, again, like Leanne mentioned, communication is key. If you don't communicate, your issues are not going to be addressed. So if you feel that you've been a subject of wrongful hiring, which probably is not the case all the time, because sometimes job descriptions don't include every single aspect of what your job entails. Sometimes there are some discretions that employers have, as long as they are within the range of the types of work that you are expected to do. Employers do have the right to get you to do that work. Everything can and won't be spelled out in a job description. But if it's so far removed from the type of job that you were hired for, where you were, to just throw a random example, you were hired for a purely technical role where you're a coder, and all of a sudden your role has changed and now you're expected to be a customer support person where you're talking to 15, 20, 30 people on an hourly basis. And that is not what you signed up for. So again, a lot of it will also depend on what the employer's rights are and how they retain those rights as part of their employment agreement. But if there are fundamental discrepancies from what you signed up for, from the time you signed up from the time you started, and there's a breakdown in that understanding, then communication is key. Understand what's going wrong and why is there a disjointed understanding between what you were offered versus what you were promised versus what you're offered. And if you're unhappy with the explanation you get, then maybe there is some legal claim that you could think about. But oftentimes, not everything ends up being a wrongful hiring.
Thank you for touching base on that. And then for you, Leanne, you had also mentioned it can become a more serious matter when an individual's human rights have been violated in the workplace. So then my question to you on that is, when does the role of an employment lawyer become necessary? I mean, aside from the human rights being violated, but aside, what would a candidate need in preparations for seeking out an employment lawyer if they feel like their rights have been violated?
That's a good question, and it's not always an obvious answer because it depends on the scenario and the situation that each person is in. When you feel that you're not sure what to do, when you feel that something has been done, and you need to do something, I at that time would seek out a consultation, because not everything is human rights related, and not all cases speak for themselves. You may have an excellent human rights case, but you might not be able to prove it. So as soon as you feel lost for what to do, that would be the best time to contact somebody. It's hard to really gauge that because you might contact a lawyer too soon, or you might contact somebody too late. But when you feel that something's not right and that it's time to do something, at that time I would seek out legal advice before you actually do anything. Sometimes people can hurt their own cases by taking the wrong steps on their own. And in a situation like that, we can only try to repair the damage as best as we can, but we can't always fix it. So that's why I would say seek legal advice before you act.
Thank you. And then this also applies to if their rights have been violated in turn under the condition of based on discrimination, correct?
Sorry, what was the question again? I'm just having a little hard time hearing you.
Oh, no worries. No, I was also clarifying that this also includes when a person's rights have been violated based on discrimination, correct? Like they you don't always know. Sometimes discrimination can be a very fine line, and for a layperson, somebody whose job is not assessing these things, it's a very hard thing to determine. And just because it's not human rights code related doesn't mean that you don't have a case. That's why you want to seek out legal advice, because a legal advisor can tell you if you have a case, what kind of case you have, and the best ways to approach it. So human rights or non-human rights related issues, you can violate somebody's rights even though it's not protected ground, but excessive bullying and harassment, just certain behaviors in the workplace can trigger damages through the courts as well. I see. Thank you. Thank you for clarifying that and touching based on that for those who, unfortunately it happens, discrimination can be very, like you said, can be a very fine line. It can be very subtle, and seeking legal advice, they may be able to pick up on things that you didn't know were actually very alarming, very discriminatory. Absolutely. We have a couple questions here from the Q&A chat. I will read them out to both of you. Sorry, give me 1 second. Okay, it says, hello, everyone. What happens if working in a team is one of the conditions specified in the job description and the employee insists on working alone? I'm not entirely sure who to direct that question to, but
I can take it.
Okay, Shefali, yes, go ahead, please.
Yeah, so it looks like the employee is basically refusing to do something that was specifically set out by as a requirement from the employer. If there are specific human rights related reasons or other medical related reasons, which is the basis why the employee is asking for such a type of a change in their role, then I think there's still some scope for negotiation and discussion with the employer. But if it does not have an underlying reason which is legally supported, and it's just as a whim or fancy of the employee, then the employer very well has a right to discipline the employee and basically insist that no, you need to work with the team because that's what your role entails. Employers do have some discretion in expecting employees to work in a certain manner, in a certain way, because they are being compensated for that. And if the employee refuses to perform a part of the duties because they just feel like it, then they may be subject to discipline. So that.
Okay, Leanne, did you want to touch to add anything to that question as well, or to what Shefali said?
No, that was a very good answer. There are certain circumstances which could merit cause for termination, and that could be seen as willful neglect of duty. If you're not participating in a manner that you're expected to participate, and the employer's requests are within reason, a reasonable expectation of your job duties, then yes, that could lead to cause for termination without notice.
Okay. Thank you. Thank you both for answering that question. We have one more question as well, and I think this relates to what we were discussing before in regards to job descriptions and knowing what your role will be in a work setting. The question is, sometimes there are other responsibilities added to the job description once the employee has started working. Should the employee claim compensation?
Well, I can jump in again,
Okay.
and because it feels like it's a continuation of the topic that I was talking about. So, and again, please feel free to jump in where you feel fit. So I think that, like I said, employers do have some discretion of adding job duties and responsibilities as you go and as you progress in your job, as long as they are commensurate and they are reasonable and expected as part of the job that you're performing. Like I said, they can't be too far removed from what your job entails, but as long as it's within the scope and it's expected, employers are not expected to pen down every single aspect of your duty as a bullet point, and only those are the duties that would be entailed. So it really depends on whether you think that you were hired for a certain reason. Like I said, go back to the same example of a technical person versus a customer rep, right? They're very different roles, require completely different skill set. If they're expecting you to do something that's an extension of the role that you're already doing and can be performed with the skill set that you have, then I don't see how that's a problem. And if you refuse, then again, like, the discipline may follow. But if you think that the role is, yeah, sure, something that I could be performed, but it's not really probably falling within the scope. It's, say you were hired in a non-managerial role, but now you're expecting to do more than that, and you're supervising a couple of people, although in the same role, then the role has evolved. In that case, you can definitely have a conversation with your employer to see if you can receive additional compensation for the additional work that you've taken on.
I see. And then additionally, and like we said before, communication is key as well. So an employee can always go to their employer and, clarify what their roles are, despite it not being, even if it may not even be in contract, they can vocalize and clarify what their roles are in the position, correct?
Absolutely.
Absolutely. Okay. Thank you. Leanne, did you want to add on to the question or to what Shefali said?
I do, actually, from another perspective, though.
Okay.
Obviously, or it's common that when a person starts in a new job, that the role evolves and certain evolutions are natural. But if you find that it's taking more time to complete your duties and you're not being fairly compensated, you do have to vocalize that to your employer quickly, because if you wait too long, so say a year into these new duties that are now taking you 60 hours a week to complete, and you're just working around the clock, but you've never said anything, to claim afterwards that that these duties aren't part of what you agreed to initially, after a long period of time, you can be seen as accepting these new duties. So if another example, a clearer example, if an employer says, I'm going to cut your salary by 20%, and you agree to it and don't say anything for 6 months, you can't say after 6 months that's constructive dismissal, because it would be deemed that you accepted this new term of your agreement. So to put that into context about adding on extra work, if you feel that this work has gone beyond the scope of what you initially agreed to, speak up quickly. Don't wait too long, because you may deplete your ability to argue that it's outside of what you accepted.
I see. Thank you. And on that same note, also, I hope that answers both your questions that you've asked in the Q&A. Thank you again, folks. Again, thank you so much to those who have been asking questions. I do encourage you all to take advantage, be a part of this conference, ask the questions that you have, and Shefali and Leanne will do their best we'll be more than happy to answer the questions for you. But Leanne, on that same topic of dismissals, that actually brings me into our next topic of discussion regarding wrongful dismissals and terminations. So I just would like for you, if you could please define what to our attendees, what wrongful dismissal is, and explain what types of wrongful dismissals exist. And then additionally, my follow-up question to that is, how do our employment rights play a role for an employee who has been terminated? Sorry, it was a loaded question, but we can start off with what are wrongful dismissals.
I understand the question. Yes, I can answer that. So a wrongful dismissal occurs when an employee is terminated through no fault of their own. They have their performance is fine. They haven't committed any egregious or wrongful acts that merit termination without cause. So not all wrongful dismissals are bad. Sometimes they're business related, or it's nothing to do with harassment or bullying, or the employee is a bad employee. But when a wrongful dismissal occurs, then an employee's rights to termination pay kick in. So, sorry, I don't want to jump ahead. You were asking what kinds of wrongful dismissals are there?
Yes.
There are the wrongful dismissal, no bad faith. It's just, what is the employee entitled to? Then there's the wrongful dismissal based on human rights grounds. The most benign of those examples would be an employee returns from a medical leave of absence, and the employer says, we don't need you anymore. We've hired somebody else to do that job, and we're happy with them. That would be a human rights related ground. And of course, there's the more egregious acts, which may or may not be human rights related, just depending on the manner in which an employee is terminated. You have constructive dismissal. That is when an employer makes it impossible for an employee to do their job. If the employer locks the doors and the employee is not able to get to their desk, that is the employer forcing the employee not to be able to do their job. That often, constructive dismissal can be the example of a 20% pay cut. That is a breach of an employment contract by the employer that the employee does not accept, and they choose to leave their job on those grounds. Sometimes constructive dismissal can occur when the workplace becomes so toxic and poisonous that the employee just cannot attend there because it creates too much anxiety and mental distress. That can also be a wrongful dismissal under the guise of constructive dismissal. So basically, wrongful dismissal occurs when an employee can no longer do their job, either through the employer's "you're done today," or the employee can't return to the workplace for various reasons due to the employer's action. And sorry, what was this? Was there the follow-up to that question?
Oh, you've answered. It was just how do employment rights play a role when an employee has been terminated?
Yes, sorry. So when an employee is wrongfully dismissed or constructively dismissed, because that essentially is the same thing as a wrongful dismissal, then their rights to termination pay and notice kick in. So the Employment Standards Act mandates a minimum of notice be paid in certain circumstances. There's termination pay, everybody is entitled to that if they've been employed more than 90 days. Severance pay can kick in under the Employment Standards Act, where if an employee is employed for a certain period of time or certain conditions exist. The Canada Labour Code also has its own termination entitlements that an employee is entitled to that differ from the Employment Standards Act. But the court has deemed that the legislation, so the Canada Labour Code and the Employment Standards Act in Ontario, as they deem that as a guideline. It's a minimum standard, and an employee can seek more through the common law if there is no employment contract that limits them to what their entitlements may be. So the legislation sets out a minimum of what an employee's entitlements are where there's a wrongful dismissal. And in many cases, an employee can get more through the courts.
They can, you said they can receive more through the courts? What do you mean by more?
Greater notice, which would be known as common law notice through the court. So just to expand on that briefly, if there is no binding termination clause in the employment contract, and most often those can be challenged. So where the courts deem there is no binding termination clause, then the court will award reasonable notice or common law notice. And that will vary based on the certain conditions of the employees, of the employee at the time of termination. Those are factors in which we refer to as Bartle Factors, and that Bartle is a case law from 1960 that says if based on how long you've worked there, how much you made at the time of termination, what your position was if you were in management or if you were in an entry-level position, your age, and a multitude of other factors at the time of termination can determine what your common law or reasonable notice entitlements are.
Okay, I understand. Thank you. Thank you. You had mentioned severance pay, and that transitioned smoothly into the next topic, which is severance pay. And this is a two-part question. The first part is for Shefali, for you, and then the second question, I will relate that to you, Leanne. So Shefali, my question to you in regards to severance pay is, what exactly is it, and how is it calculated in Ontario?
Sure. So oftentimes severance pay gets confused with the common law damages that Leanne just spoke about. But specific to Ontario, there is something called statutory severance pay, which comes out of the Ontario Employment Standards Act. There's also severance pay under the Canada Labour Code, but that's for federally regulated employers. But if you talk about severance pay, it's a statutory entitlement that's coming out in Ontario. And what the Employment Standards Act, we call it the ESA, what it provides is, this is the amount that the employee is expected to receive if certain conditions are met, and I'll get into what those conditions are shortly, in addition to the termination notice or the pay and layoff notice that the employee is entitled to under the Employment Standards Act. So just to give you an example, under the Employment Standards Act, which is the minimum entitlements that the employees receive, employees are entitled to anywhere starting from 1 week's notice or pay and layoff notice up to a maximum of 8 weeks, depending on the years of service. So, and the 1 week starts to kick in from the time they've completed 3 months of employment, and it starts to stagger and start increasing to 2 weeks, 3 weeks, 4 weeks, depending on the length of service. Now, this is the termination notice that the employer is expected to provide to the employees at the time when they're letting them go, or instead they could give them pay and layoff notice. If they want to let them go immediately, then you pay them for the 2 weeks or the 3 weeks notice. Okay. Now, in addition to that, if employees have been employed with the same employer for over 5 years, and the employer has it's a two-part test. It's A, the employee should have been employed for 5 years at least. That's when the entitlement to severance pay gets triggered from the employee perspective. And B, they should have been employed with an employer whose annual payroll is over 2.5 million. That's one. Or if it's not the 2.5 million test, if you're being let go because the establishment shut down, and you're one of the 50 or more people who's being let go in a period of 6 months, even in that instance, severance pay applies, even if the employer is not a 2.5 million organization. So those are the conditions that should be met for an employee to receive severance pay in Ontario, and that is something that is in addition to the termination notice or pay and lieu notice. And the calculation for severance pay, sorry, was that the second part of the question? How is it calculated?
That was part of your question. How is it calculated?
Yeah.
I haven't asked Leanne hers yet.
Yeah. So how is it calculated under the ESA? It's 1 week per year of service. And there's a maximum cap on severance pay, and that's 26 weeks. 26 weeks of pay.
Sorry, you said 1 week per year?
Of service, yeah.
Of service. Okay. And up to 20?
Up to maximum of 26 weeks.
Up to max 26. Okay, 26 weeks. I see. I didn't know that. I did not know that.
So if you're a long service employee, say, for example, you've been there for 26, 27 years, then you're getting 8 weeks of notice of pay and lieu of notice under the ESA. And assuming that you're not being let go because the employer's establishment is shut down, but the employer has a payroll threshold of over 2.5 million annual payroll, then you would also get 26 weeks of severance pay.
See, okay.
Because you've been employed for 26 years.
For 26 years. Okay, I see, I understand. Okay. And then Leanne, my question to you in relation to that is, what's included in a severance package?
Well, really depends a lot on what the employee had at the time of termination. Now, the statutory severance package, in the 8 weeks, not the 26 weeks or the severance portion, but during the termination portion, which every employee is entitled to, they are entitled to their full benefit complement. So their health and dental, their pension, life insurance, anything that they would have had during their regular employment, including their right to vacation pay and commissions or bonuses. Now, that termination period, and I'm not sure if Shefali explained that because it's a little bit difficult to hear, but I think she did. But during that termination pay, that can be given as working notice. It does not have to be paid. So they could say your employment will end in 8 weeks. And your last day will be 8 weeks from today. However, the severance portion must be paid out as a lump sum unless the employee agrees to take it in pay continuance, and they must agree in writing. But the benefits are not required under the statute to be paid during the severance portion, that 26-week period that was mentioned there. So your benefits by statute are only during the termination portion. Now, when you're negotiating a severance package, that is a different matter altogether. That's a negotiation. So we seek notice. And in some courts, now, mind you, I deal with the small claims court, which is different than the higher court. The law is the same, but the small claims court is more restrictive because it is, as the lowest court in the land, it cannot make new law. It cannot go outside what the higher courts have ruled. So that, and with law, it's a ranging. These matters are always ranging and varying from courtroom to courtroom, judge to judge. So some judges will include the severance package. We seek that, especially, and we can make the argument, especially where the employee is reliant on those benefits, health and dental. Some people have health conditions that require expensive medication. So we tend to want to negotiate these matters without going to trial, because trial is a long way off and it's an expensive venture. And these matters tend to speak for themselves. You don't go to trial when you know that you're going to lose. So most employers will try to mitigate their damage and settle out quickly, or settle out in a manner that's going to, save them a little time and a little money. And also the employee. If the employee finds a job quickly and their damages are limited, they may not want to go through the whole court process just for a few, a few $100s more. So things like benefits and bonuses and vacation pay become negotiating tools.
I see.
And depending on, now I've had, a lot of times I often waive those to be able to settle a case without depleting its value too much. But I had a case where a lady spent $1,000 a month on medication, and we negotiated based on her benefits. Whatever we decided, whatever we accepted had to include the benefits.
Okay.
So it really, when we're talking about a common law package, it really depends on what's important to the employee at the time.
And does this employee need to accept the deadline? Do they need to make a decision on whether or not they choose to accept the severance package by the employer's deadline? Because I've heard that some companies, some employers will give a certain deadline, but is a employee required to make a decision by said deadline?
Well, if they don't intend to accept the offer, no. The deadline is, if you intend to accept this offer, let us know by this time. So if they don't intend to accept the offer, no, they can ignore the deadline. If they don't know and they want to seek legal advice, then the best course of action would be to ask for an extension so that they could get proper legal advice. Now, legal advice would benefit an employer, because if an employee was told by a legal advisor, this is a good package, you should accept it, and they sign a release saying, I knew and understood what I was accepting, then the employer is off the hook. So an employer shouldn't be afraid of an employee seeking legal advice. If the employer says, no, you accept this now or you get nothing, that would be a red flag to say that what the employer is offering is probably a lot lower than what you could do at court, or if you were to challenge it. So you probably would be better off just ignoring it and not signing and seeking help at that time.
I see. Thank you. Thank you so much for answering that. And then my final question in regards to severance pay is towards to you, Shefali. And the question is, does a company have to, this is more of a true and false statement, and just wanted to see if we can dismantle this myth or claim it as a fact. And the statement is, a company doesn't have to pay me severance if they are closing down.
Interesting one. So the answer is that's not true, unless the closure is because of a financial, the company is able to prove that the closure is due to a strike or a financial burden that was caused due to a strike. That is a specific exemptions that's set out in the ESA for when severance pay is not payable. There are also multiple other reasons why severance pay or when severance pay is not payable. But if it's just a company shutting down for their own financial reason or restructuring or whatever, that's not an exception per se. So the employee, if they ended up working for 5 years and the employer meets the test of a severance employer by having a payroll of more than 2.5 million annual payroll, then severance pay would be payable.
I see.
And just to broaden on the different types of things that are exceptions when severance pay is not payable, because it's also important to know and not just to assume that severance pay would be payable in all scenarios, because that's not true. If an employee's employment is terminated due to willful misconduct or disobedience or willful neglect of duty, tying it back to not performing the duties that you knew that you were supposed to do, even when the employer has repeatedly asked you to do them, and then the employer, as a way of discipline, terminates your employment, then in those circumstances, employees won't be entitled to severance pay. And then if an employer provides a reasonable alternate employment to the employee from the same employer, and when I say reasonable, the pay is pretty much the same, you're going to the same place, you're working with the same team, it's just a different role, what matters your skill set, and you say no to that, and in response your employment is terminated, then there are circumstances where that's a circumstance where severance pay may not be payable. Specific example, another one is construction employees. There's a very specific definition for construction employees. So construction employees also don't get severance pay.
Oh, I didn't know that. Okay.
Yeah, and it's severance pay and also the termination and notice for termination. Because the expectation is that the job is so sporadic that the employer would be, it's like penalizing the employer to expect that every time they're letting go of a construction worker, and they have to think about giving notice or penalty of notice. It just doesn't work out. It's just.
I see, I see. Leanne, sorry, you were gonna say something?
Well, I was just going to say, yes, with construction workers and prescribed workers, seasonal workers, they are exempt under the Act from receiving notice and termination pay. But there is a caveat to that. In this circumstance, so landscapers and snow plowers are considered as prescribed workers or seasonal workers and may not be entitled to termination pay. But if they work for the same company year after year and they are laid off and recalled and laid off and recalled and then terminated, they can seek common law notice if there's not an employment contract that limits them to their Employment Standards Act entitlement. So if a landscaper works for a landscaping company for 10 years and he has a valid binding contract that says in the event of a termination, you will be entitled to the Employment Standards Act minimum, then no, he could not seek termination pay or he could not seek common law notice through the court. So even construction workers in certain circumstances could seek relief through the courts.
I see. Okay, thank you. Thank you so much for both of your sharing both of your inputs on the topic of severance pay. I think that's a very important discussion to address. The next thing I want to talk about in our conference is retention and turnover rate. I would like to turn the attention onto you, Shefali, and first ask, what is employee retention and how do companies benefit from employee retention?
Great question. Yes, absolutely. So the term employee retention typically refers to the strategies and processes that organizations develop to keep its talent and employees and mitigate turnover risks. There are two topics intermingled, and I guess we will deal with each of them separately. Employee retention and turnover, they go hand in hand. And it's a leading workforce management challenge for many organizations and HR professionals, because it creates significant operational costs for employers and compromises growth and profit. So you want to be mindful of that. Employee retention matters because replacing employees could cause, like I said, a huge financial impact. For example, the cost to replace an employee can range from 1.5 times to 2 times the employee's annual salary. It seems as if the employer is just recklessly letting go of employees, but that's not actually true. And also it impacts the company culture, employee satisfaction, and other soft costs also add up. So moving into the next part, benefits. What are the benefits of employee retention? Employee retention it's not just about minimizing damage to the organization when employees leave. It actually offers opportunities to improve company performance across a number of key metrics. Like, for example, cost reduction is one of them, but you need to think about morale improvement by having employee retention. If it seems like it's a revolving door environment, then it can dampen employee morale. And you lose connections. Employees who remain may have to take on heavier loads of responsibilities. Never a good sign when employees are stretched thin. The other benefit is by having employee retention, you have your key experienced employees and you're not crippled by the cost of high turnover, by loss of institutional knowledge or skills or relationship. And another important benefit is increased productivity, because you're really focusing on getting the work done as opposed to focusing on how do I fill this role. Right. And then it goes hand in hand with better employee experience, because you're working in a team, you're not taking on an extra load because there's less bodies in the team. So that leads to better employee experience. And also it goes to improved employee engagement and satisfaction, because there's a positive employee experience can boost employee engagement. So those are some of the benefits that employers have when they have good employee retention.
I see. Okay. And then going into, you had mentioned employee culture or work environment culture, and that actually brings me to integrate the next topic, which is barriers placed upon racialized individuals. And so I'm curious to know, how can law firms or just companies in general reassure their employees that they are valued and deserving of advancement? They are valued as an employee, regardless of their race, gender, and creed. How do they promote equity, diversity, and inclusion? Because I can assume that those are key factors to build a positive retention. Is that the right word to use? Positive retention.
Yeah.
Yes. So with that in mind, how on the topic of diversity, equity, and inclusion, I see that as a key factor to, keeping your employees. So how can companies promote that and reassure their employees that they are valued regardless of their race, their gender, their sexuality?
So you just cut out a little bit there towards the tail end, Khadija.
Oh, sorry. No, I was just, so to summarize, I was just asking on the topic of diversity, equity, and inclusion, when it comes to having a positive retention rate, what are some key things that companies can do to show their employees that they are valued, regardless of their gender, their race, or their creed?
Right. Okay. Well, I think that's a packed question. So let's unpack a little bit. I do want to talk about what equity, diversity, and inclusion means in general to me. And I guess in general sense. And then from then we'll move on, because that kind of lays the foundation as to how I think employers can do better by including equity, diversity, and inclusion in their workplace. So equity to me is that every person is judged on their own merits, work and potential, and their individual personal characteristics can be accommodated to the degree possible to enable them to contribute and succeed. And that's important because you're not just looking at a multitude of factors that take into consideration merits and potential and personal characteristics. And diversity is welcoming and supporting people from all cultures and all backgrounds with all personal characteristics. That's how I perceive diversity to be. And inclusion to me it's that constant conscious effort to involve in all aspects of, say, practice, when I'm talking about work in the firm, in all aspects of practice, every person who might be excluded on the basis of backgrounds or personal characteristics. So specifically making sure that everybody who may or could or would have been excluded for their basis of background, you specifically include them in all forms of practice and in life or in firm. So this is how I perceive equity, diversity, and inclusion to be. And then how can companies or how can employers assure employees that they're valued and deserving is, I think, well, I can give you example from my own self. I feel I'm reassured that I'm valued and deserving of advancement because I know that personally my firm is engaged in actively recruiting professionals and staff of all backgrounds and characteristics, making appropriate accommodations, like I said, and meeting individual needs. And I see that they're putting a lot of effort in continuously re-examining and improving their policies and practices and trying to remove those little barriers that could, with respect to retention or advancement and success of the individuals. To give you a more specific example, I am a NCA candidate. So what it means is that I got qualified to be a lawyer in India, and when I moved to a common law, when I moved to Canada, I had to go through the NCA process to kind of get accreditation that yes, I am, I have the credits worthy enough to be a lawyer in this country. And it's very difficult when you go to a hiring, when you go through a hiring process and you're trying to explain to your prospective employer what your credentials meant from another country. Because if you are dealing with a recruiter or an employer who's only been exposed to the Canadian set of credentials and the credits that you would get in a Canadian law school, it's very difficult and hard to kind of try and explain to them what your grades meant from back in India and what your experience meant. What is, okay, it's a top tier firm. How do you compare it to a top tier firm here in Canada? So my experience with my firm has been very pleasant so far in that place, in the sense that I felt that they asked the right questions to understand the experience that I had. They tried to look fast instead of comparing the credits as to how the credits would be back in India versus how it worked. They actually looked down to real work experience rather than just the grades. And based on the interview process, took a chance and gave me an opportunity to prove myself. And only when I started that, I realized that they've done this over and over again, because there were at least 6 other NCA candidates within just the Waterloo region in my firm. So that to me was a big reassurance that, okay, this is a firm that actually values people for the talent and the value that they bring with their diverse backgrounds. So that's a pinpoint example from my own personal experience as to how I think companies can assure employees that they're valued and deserving.
Oh, thank you for putting a personal touch onto the question. That I always value that as well. It's not just, oh, it's this, and that, but when you add your own personal touch on it, it's more relatable. And I'm happy to hear that it was such a positive experience for you from the moment you had the interview up until you being officially hired, and seeing that this is something they focus on very much. You said that they do this over and over again. This is one of your observations with the firm. So that's really great to hear. My other question regarding to that topic is from an employee's perspective. So aside from looking into the company itself, but what are some key factors that candidates should inquire about a company to know if they're a good place to work, especially from a visible minorities perspective? One example I have would be like for me, not for me, sorry, but someone has told me that prior to applying for a job position, they actually go into the organization and see who works there and see if there's anyone that looks like them. And I think that's very important to see. It's the similarity, the familiarity between that person and who works there. So from your point of view, what are some key factors that candidates, visible minority candidates should look into a company before applying to see if they're a good place to work at?
Yeah, well, I actually like the example that you gave. I really like the aspect that someone's going onto the website and putting in the effort to see who the team is and what they entail and all of that. I would actually go one step forward, and before applying, I would even send in, a virtual coffee invitation, because we live in a virtual world these days, just to catch up and try to understand from their perspective how they perceive the company culture to be, because there's nobody else better than existing employees who would speak to the culture of the company as opposed to your perception of what the company would be based on their website. So I would encourage candidates to see if they can. They might not be successful all the time, but in my own personal experience, I've seen and I've experienced that a 5 or 10 minute coffee conversation, back in the day, it was actually not virtual coffee. So I still, I remember the days where I had a spreadsheet with a list of people that I wanted to meet and then just have this conversation just to understand. And these conversations needn't be that I need a job, that's why I'm meeting you, but it can just be to understand what is expected, how is the company culture, what are the expectations in terms of, are there growth opportunities, are there training and development opportunities, educational opportunities, whatever seems important to you at that point in time. You probably want to get some input on that from people, who are already with the organization. So I guess that's a good thing to do. And based on that input, I think it's a very important factor to understand, get that feedback, and kind of helps you assess whether or not you think the company is a good fit for you, as opposed to company assessing whether you're a good fit for them. And I think it's also important to understand a little bit about the financial stability of the company. If you're an immigrant and you're moving to Canada recently, and then you want to make sure that the time and effort that you're putting in, sure, not everybody has that option, but if you do have the option and you have the pick of the lot and you've got 5 offers and you want to make sure, I don't know which one to go to, you would probably zero down on, the values that the company believes in. Do they echo with your own values, and opportunities for growth and team support and training and development, and on top of that, the financial stability of the company. You don't want to join a company that is going to go down the road in the next few while. Right. So yeah, that's probably what I would think about if I was back in the market.
No, and you brought up a good point is with the financial stability, because especially in today's time with the pandemic, certain organizations, certain companies, have been plummeting financially. Some companies have to close down and then have to reopen, and that is cost effective. That does incur expenses on them. And this pandemic itself has caused some financial strain on a lot of organizations. So I think that is very important to look at before applying to a job, to an organization, is the financial stability. I never thought about that. That is a very good point. Leanne, did you have any points that you'd like to add in addition to what Shefali has said in regards to? Yeah, sure.
Well, just a few things about, when you're looking at a company for new immigrants, perhaps especially, also for, people that are, well immersed in the Canadian culture, but you want to look at the type of business that it is and the culture of that kind of industry. Working in an office is very different than working in a restaurant or a call center or a retail store. So you want to kind of know what to expect from the kind of place that you're going to be working in. For example, restaurants have a high turnover rate, yet this particular restaurant, their employees have been there for years. So that's a good sign. Whereas, an office, an accountant office, where their employees stay and come and go within a year, that's not a good sign. Also look up the company's Google reviews. That can tell you what kind of company it is. If they have good Google reviews, what to do a Google search to see if the company is in the news. So there are various ways to get a feel for the company and how they act. Oh, and very importantly, if you want to see what kind of culture that you'd be working in, Glassdoor is a good place to go, because you can see what companies employees who have left companies have to say. Were there, did they leave on good terms? Were they treated right? So there are, nowadays with the internet, there's a lot of options, a lot of ways a person can have a peek inside or peek behind the curtain before they actually make their choice as to what, if they want to accept a job offer or not, if they're in the fortunate position of having a choice too.
Mm-hmm. I agree. I've never Glassdoor. I've heard a little bit about that, but I guess that's more for, what would be the difference between that and Google reviews, or is there not much of a significant difference?
Google reviews are customers. In their experience with the company, and Glassdoor are employees leaving comments about the company. I worked for so-and-so company, great place to work, pays very little. Or, great place to work, the staff are fantastic, the pay was great, opportunities. So the Glassdoor will give you an idea of what employees think of their employer, some of them that are still employed there and some of them that have left.
Okay. Oh, that's very helpful. I like the distinct difference between the two. And then my last question under the topic of retention and turnover rate, and because we mentioned it before with the pandemic, Shefali, this question is for you. And do you believe that this pandemic has brought on an advantage or a disadvantage, or maybe a bit of both, to the Canadian company's turnover rate or employee retention? I know you had mentioned before with the financial, the financial disadvantage, but what are there any other disadvantages with with companies' turnover rate because of this pandemic, and advantages, of course, too?
I don't necessarily see it as an advantage or a disadvantage, but I do recognize that the pandemic has brought out about a lot of change, which has resulted in a lot of options for both employers and employees. I know now that it's an employee market right now, and employees have multiple options because they're no longer limited to their geographic restrictions because of the work from home and the virtual offices. The same goes for employers as well, but employers obviously have certain other considerations that they need to keep in mind before they hire employees, because they have, laws and the taxes and all of that would apply to them. So I guess it's an advantage for employees when it comes to that. But if the employers can look beyond the tax and the legal issues that entail by hiring people from different jurisdictions, I think it's an advantage for them too. And I think pandemic also has opened up an opportunity for employers to improve or reinvent themselves from what they already were. Because if one of the primary reasons of turnover rate for an employer during the pandemic is, and of course they'll find out about that if they conduct an exit interview, which I almost recommend all my clients that they do, and if they find out that it's compensation related, or if it's culture related, or there are different buckets, and if they really pin down as to what is the reason for the attrition or the turnover rate, then I think that presents the company an opportunity to reinvent itself, or upgrade itself, or try to provide that average or at par with what the market is. And then in that case, I guess that'll increase their employee retention. And it really doesn't matter whether there's a pandemic or not. Then if it's really a good company with good pay and good culture, then it's just for competition. It's just healthy competition at that point and nothing else. So that's my take on the pandemic. I think it really depends on your perception. And if you're stuck in your ways, I think it's unfortunately probably could be a disadvantage. But if you're up for a challenge and you are up for a little bit of a change, then it's probably more advantageous for you.
I see. Thank you. Thank you for answering that. Ladies, my last question to you both, just, some final thoughts is, what is one final, with everything that you have mentioned earlier in this conference, what is one final takeaway piece of advice that you'd like to give our audience when, in your case, Leanne, when seeking legal help in such cases as being wrongfully dismissed, and also with severance pay? And then for you, Shefali, what is a final takeaway piece of advice that you would give when coming up with solutions for removing barriers towards employment advancing, and then also for companies to maintain the retention rate? Leanne, may I please start with you?
Okay, well, my advice to people, the final takeaway would be this: employment law is a vast industry that is evolving. Currently, it is evolving on a daily basis, and it's impossible for an individual to know what to do at that right time. Always seek legal advice. The biggest challenge in my industry before the pandemic was educating the public. And if I could say that there is a silver lining in the pandemic, and I don't say that lightly, but is that more people are now becoming aware that they have employment law rights, and they are calling rather than waiting until after the fact or assuming that there's nothing that can be done for them. Right. People know now that their rights are much vaster than what they realize. And so my advice to everybody is call, ask. It doesn't hurt to ask. Right.
I agree 100%. I mean, on one side, it does suck, to be candid. It does suck that it took, a pandemic, an unfortunate pandemic, for people to be more aware of their rights. However, at least now the bottom line is that people are now becoming more aware of their rights.
Right.
Yeah.
And if I just could just sorry, one last
Yeah, of course,
add
of
on
course.
to that is that it's not it's no longer unusual to be terminated in Canada. That is a part of our work culture. At some point in your working career, you are very likely to be terminated with cause or without cause. You are very likely to experience something in your workplace where at some point you will need legal advice. So it's not a stigma, and it feels like a stigma, but it's really not, because that is just the culture in Canada now. We've all heard the expression gig culture, where people are, you're considered a long-term employee after 5 years now.
Oh, interesting. Okay. 5 years. Wow. Okay.
Yeah, most people aren't in their employment. Most employment does not last 5 years. A lot of people, I'm not saying that everybody is, by 5 years you're gone, but that's it's not unusual to be terminated within the 5-year mark.
Oh, I see. That's very unfortunate. And then for you, Shefali, on the topic of removing barriers, and then for companies to increase their retention rate to, bring in and attract and keep their employees, what is a piece of advice that you'd like to give?
Sure. For employees, as far as removing barriers for employment advancement is concerned, I think, and it's been repetitive as part of this conversation, is communication is key. If you think that you're not being treated properly, or there's something wrong that's going on, instead of assuming the worst, ask the right questions. Reach out to your employers, understand clearly what your expectations are, and try to meet them. Or if they don't match up, try to understand why they don't and try to address those concerns. Without communication, there is no discussion and there is no scope of advancement. So I think communication is key. And as Leanne mentioned too, it's important if your communications can be in writing, make it in writing. But without communication, there's no start. And for employers, about retention and what is a key thing or key takeaway, I would say, is get feedback from your employees, get feedback from your existing headcount. Without the feedback, if you just keep on implementing amazing strategies which you believe are amazing without really getting stakeholder consultation or people who are actually going to get affected with those strategies, you're not doing a good job. You need to ask for feedback before you implement something. After you implement something, really look at that feedback, see how you can work or address the concerns that are raised in the feedback, and move forward from there. At least that shows that you are making an effort to make it an inclusive workplace. You're making an effort to actually retain employees and you care about their well-being. Without that, and of course, there are multiple other factors. If I had to pin down on one thing, I think it's feedback. But yeah, those would be my two main key takeaways.
I agree 100%. Thank you. Thank you both for sharing your piece of advice. I'm sure that it was very helpful to our attendees. It was very helpful to me. Shefali, Leanne, this has been such an informative, very interactive and engaging conference. I like to thank you both for choosing to be a part of this panel discussion. I certainly learned a lot from you. I even wrote notes down as we were talking. I'd like to thank everyone in attendance for joining us today. I'd like to thank you for your questions. Absolutely. I hope that you all were able to take away from this conference some piece of information, and also questions that you had that were answered. I hope that they were answered in today's discussion. Folks, just so you are aware, as I said before, this is an ongoing series of our employment equity and rights series. Our final panel discussion will be held in March, towards the end of March. So please keep an eye out for the official date announcement on Connect Your Canada's LinkedIn and Facebook pages. If any of you would like to personally reach out to Leanne or Shefali themselves, I will go ahead and include their contact information in the chat below for your own personal use here. Once again, thank you so much to our featured panelists. Shefali, thank you so much, Leanne, who is here. Leanne is here with us, I said, on the phone. Thank you so much for both of you for joining us today. And we hope to see you at our next conference, everyone. Thank you so much. Thank you.
Thank you.
Thank you. All right. Have a good day, everyone. Thank you so much.